Formally start this May Good Morning Schaumburg. Thank you all for joining us this morning, and very excited about the toolkit that will be shared today and the discussion that will ensue from Lavelle Law. So thank you, Lavelle, for bringing today's topic to the Schaumburg Business Association. And I want to also welcome, I see Village Trustee Brian Bischke is on the call. Welcome, good morning.
Good morning, everyone.
Marilyn Carr, Village Clerk, will also be jumping on if she is not yet on. And then I also wanted to thank those members today who are supporting today's event. We have Harper College, Links Technology, Vicarious Multimedia, and the Village of Schaumburg. Harper, Links, and Vicarious. Melanie is 25N is in her background. Brittany is black and white striped shirt. Amy, I don't know if Amy's on yet. They all have raffles. So if you are interested in being eligible to win one of their raffles, shoot them a message in the chat. That being said, we will be utilizing the chat throughout today's event. So make sure you know where it is, have access to it. If you have any questions, feel free to let me know. And then I also wanted to welcome those board members of the Schaumburg Business Association who are joining us this morning as well. When I say your name, if you want to give a wave, if you are viewing this in gallery that you'll be able to see everybody, we have Heather Larson with Meet Chicago Northwest, Lori Urbanak with the Daily Herald Media Group. I don't know if she jumped on yet. Some will still be jumping in. Mary Sproat with Top Golf. Hi, Mary. Matt Hancock with Consumers Credit Union. Jeff Miller with Divine Signs, Heather Lloyd with Woodfield Mall, Brittany Street with Links Technology, and Jim Burke with Links Technology, and Ted McGinn with Lavelle Law. And then we have our chairman of the board on the call with us, who I'd like to hand over the microphone to for just a bit, and that is Carrie Ann Ryan with Chicago Office Movers and Midwest Moving and Storage. Carrie Ann.
Hi, everyone. First of all, I just want to welcome everyone to another great Good Morning Schaumburg. Thank you all for being here from all over, home, offices, and in your car. We appreciate you guys. We appreciate our sponsors and our founding members who are on today. I wanted to just give a quick shout out about our golf outings that are coming up. We have our ladies and our men's golf outing, our golf classic, sorry, not men's, ladies golf outing and golf classic. We are just about sold out on those events. So I just, want to give a quick shout out and make sure if you were planning to attend that you've gotten your registrations in and you're all set for a fun day. That and so many other fun things that we have to look forward to this year as things continue to change. We open back up and we look forward to continuing to mesh these virtual events with a hybrid event, with in-person events as we continue to open up and do more things together. So with that, I think I am going to pass it over to Ted McGinn, who is going to be moderating our fantastic presentation today by Lavelle Law. So Ted, why don't you take it away?
Thanks, Carrie Ann. Good morning, everybody. My name is Ted McGinn. I'm with the firm Lavelle Law. We are a full-service law firm. Our main office is located here in Schaumburg on Meacham, 1933 North Meacham. We also have an office downtown in the Loop, if that's more convenient for anybody to meet with us there. I want to introduce some of the other speakers today. I'm going to be talking a little bit on entity selection. We also have with us Steve Migala. Steve is a shareholder with the firm. He practices in the area of mergers, acquisition, corporate formation, some estate planning, and real estate. Steve is going to be talking about shareholder agreements. We also have with us today Samantha Bonamassa. Samantha is of counsel with Lavelle Law, and she practices in the area of securities law. She'll be talking about some of those security law issues that may be present when you're considering ramping up your business. As I mentioned, Lavelle Law, we're a full service law firm. We have attorneys that practice, of course, in business law, including corporate formation. But beyond that, we have attorneys that do a number of different practice areas, including estate planning, litigation, both commercial litigation, personal injury, family law, divorce, custody matters, also real estate, and a number of other different practice areas. I would also say that we are always willing to sit down with new potential clients, provide them with a free, no obligation consultation. So if you or you know somebody who's considering finding an attorney, finding a new lawyer, maybe a second opinion, by all means, keep us in mind. We'd be happy to sit down and talk about their legal issues. So if you can kind of jump into the next slide. There's our panelists, as I already introduced them. They'll be talking a little bit later. Samantha on security law issues, and Steve Migala will be talking about shareholder agreements. I'm going to talk about and kick this thing off with entity selection. Obviously, that's an issue that you need to consider. When you try to go ahead, go to the next slide, please, or the first slide. Yeah, obviously, this is we're not intending here to give you legal advice today. Of course, this is just for informational purposes only. By all means, for us to provide any sort of legal advice to you or to set up an attorney-client relationship, we would like you to come in, meet with us, and we can kind of hear the specific facts and circumstances relating to your business. But for today's purposes, this is just informational use only. Next slide, please. Next slide, please. All right, entity selection. When you're thinking about starting a business, one of the first decisions you have to make, the first legal decision, of course, obviously, you've already talked about the business, what you're trying to sell, goods, services, the marketplace, what are the competitors doing out there. You've already gone through all those issues, but now you need to decide what is going to be the proper entity to use to operate your business. And, there's a number of choices to consider. I would always recommend when you're making this decision, you should always consult with an attorney. You should always consult with an accountant because taxation is always a big component in this evaluation. But this is a decision that you need to make. And sometimes this can be challenging because, what may make sense today, a couple of years down the road may not make sense. So you got to kind of look forward in the future and try to project what your needs may be. Next slide, please. Okay, now, one of the questions that always occurs to me when I'm sitting down with clients is competitive advantage. What is your competitive advantage? And this is not really a legal concept, but this is something I think all businesses need to think about. And when I say competitive advantage, what I'm saying is, what is it that you have that your competitors do not? What makes your business special? That could be perhaps you provide goods and services at a very high quality, or perhaps you provide the goods and services at a cost or a price point that is beneath your competitors. Or maybe you have a patent or a trade secret. What is it that you have that your competitors do not have? And if you don't have a good answer to that question, you may be, facing a very difficult, challenging, competitive environment out there. So always keep that question in mind, what it is that separates your business from the competitors. Another concept that you're going to be hearing a lot today during my presentation is limited liability. What does that mean? It's an important concept, and I think it's really relevant when you decide what is the right entity to select. What I mean by limited liability is the general proposition that the owners of the business are not generally liable for the debts of that business. Or to put it a different way, a creditor of the business cannot try to resort to the owners to satisfy their claim. For example, if your business, you may enter into a contract with a supplier to acquire inventory or raw materials. Limited liability would mean that supplier would not be able to resort to collect from the individual owner. And so, that's a concept that you need to keep in mind as we'll get into some of these entity selections. Lastly, cash flows. Obviously, I don't really spend a lot of time talking about that, but cash flows is important when you're running your business. Do you have a way to provide some cash in case cash flows are always going to be uneven? So again, that's an obvious thing. So move on to the next slide, please. All right, so entity selection. We have a few choices: sole proprietorship, partnership, limited liability company, corporation, and then I'll spend a little bit of time talking about non-for-profit corporations. I'm not going to spend much time talking about partnerships. The reason being, partnerships generally just are not used today. And the main reason why they're not used is unlimited liability. There's no limited liability protection for partnerships. And furthermore, because you have multiple owners, each owner is jointly and severally liable for any claims or debts that are created by that partnership. So partnerships is something you just don't see very much anymore today. Next slide, please. So when we look at the entity selection, we look at probably 4 primary factors when we're trying to decide, which entity is best for you. First factor, ease of formation. What are the steps necessary to create that company? Number 2, limited liability. I kind of talked about that concept, and as you will see, not every choice provides limited liability. Number 3, taxation. Taxation is a critical component, often driving your decision making for this question. And then lastly, flexibility. How does this entity, is it flexible? Does it enable you to accomplish a lot of things? Because as I mentioned before, down the road, you don't really know what the future holds for you, and having that flexibility is something that's kind of important, kind of nice to have. Next slide, please. All right, so limited liability company. So this is a choice that's very popular these days. First component, ease of formation. What is create a limited liability company? There are some steps you have to take. First of all, you have to file articles of organization with the Secretary of State. Could be Illinois Secretary of State, but it could be wherever you're going to create that entity. But there is some formalities involved with creating a limited liability company. Also, you would file for and obtain your tax identification number. But aside from those 2 steps, it's not a whole lot of formalities. We'll distinguish that a little bit later when we talk about corporations. But creating an LLC, there's not a whole lot of steps involved. There is some formality, but not a significant amount of formality. Taxation. So with the limited liability company, you do have a number of choices, a way to handle this. And a lot of it depends on the number of members being the owners of the entity. If it's a single member, it's generally disregarded entity. So it's treated almost as a sole proprietorship for tax purposes. And what that means is that the income generated by the company is reported on the Schedule C of the 1040 of the owner of that LLC. In addition, the default taxation is partnership. And what that means is they're a flow-through entity for tax purposes. So the income that's generated by the LLC flows through. Now the LLC will file a return with the IRS, but the LLC doesn't pay tax on that income. That income it flows through to the owners and reported in the K-1, and then the individual owners have to recognize that income on their own 1040. So with a partnership, the default structure for tax purposes, it's a flow-through entity, which is kind of important because you avoid double taxation. We'll talk about double taxation when we get into corporations. And then thirdly, you could elect to have the LLC taxed as a corporation. The Internal Revenue Code has check the box regulations which allow you to, if you wish, you can select the LLC to be taxed as a corporation. And there should be reasons why that's important and beneficial. And again, we'll get into that when we talk about corporations. But those, from a taxation standpoint, you do have some choices there with an LLC. Next concept, limited liability. Oh, keep the last set, sorry. Limited liability. With an LLC, you have limited liability. So that makes an LLC very attractive when you're starting a business. That provides a shield for the individual owners from the claims of the creditors. And again, that's the general rule. An operating agreement. That is something we would recommend that you have. An operating agreement will indicate and demonstrate who the owners of the LLC are. And then furthermore, it will get into some ownership issues which are kind of important. And Steve Migala will be talking about some of those issues later on. Last concept, this is kind of a bonus here. LLCs, you have what is known as a series LLC, which is kind of a new sort of concept. It gives the ability to set up multiple series where you can insulate one business from a different business, almost as if you got a parent subsidiary structure. So that, again, LLCs are very flexible. They give you a lot of flexibility. That's why LLCs are very popular. Next slide, please. All right, corporations. So from a formation standpoint, corporations, there are some formal steps that you have to take in order to set up a corporation. Similar to with an LLC, you have to file articles of incorporation with the Secretary of State. In addition, and you don't have this with an LLC, but with a corporation, there are organizational minutes or meetings with shareholders, meetings of board of directors. Those should all be memorialized in resolutions and minutes. You should adopt a set of bylaws. There should be stock certificates. So with a corporation, as you see, there's a lot of more steps involved, more formation. So creating a corporation can be a little bit more difficult. Taxation. So a corporation is a separate and distinct legal entity. It's separate from the owners. You have a tax ID number. And so in the eyes of the Internal Revenue Service, it's this living being essentially, and it has assets, it earns income, it can sue and be sued. And accordingly, it has to file its own tax return, and a C Corp has to pay tax on the income it generates. And then when that C Corp distributes those profits to the owners, that's called a dividend. The owners will have to recognize that dividend income on their own 1040. That's known as double taxation. Okay, that's not good. We don't like double taxation because you're paying tax on the income twice. So from a regular corporation, taxation can be kind of a negative factor when you're trying to decide whether you do a corporation. Now, there's also an S corporation. S corporation is a regular corporation, but the difference is you elect to be taxed under subchapter S of the Internal Revenue Code. What that does, it flow through tax treatment, which is so you avoid that double taxation. The corporation still files a tax return. However, that income is allocated to the owners. It hits the shareholders' tax return, and they pay tax. So there's only one layer of taxation. The problem with an S corporation, though, you start getting into more restrictions. There are some requirements to become an S corporation. First of all, you're limited in the number of shareholders. You cannot have more than 100. And you may think 100 is a lot of shareholders. Well, if you're going to raise capital, and Samantha will talk about this later on, you may be seeking more than 100 owners. So an S corporation is something that it could be restrictive in that standpoint. Number two, the ownership shares, you have to have one class of stock. So that takes away from some of the flexibility. Number three, only individuals in certain trusts can be shareholders. So if you're a corporation, corporations generally cannot own shares of stock in an S corporation. And then finally, shareholders cannot be non-resident aliens. So again, there's some more restrictions in becoming an S corporation. Now the S corporation is nice because you avoid double taxation, but again, you have those restrictions. Next factor, limited liability. A corporation, whether you're an S corporation or a C corporation, you have limited liability. So that's a good factor, a reason why corporations are very attractive. And lastly, a shareholder agreement, we would recommend that you have one. Steve Migala will talk about that in a little bit later on. Next slide, please. Sole proprietorships. Well, sole proprietorships are probably the most common business structure out there. The reason is formation. It's so easy to create a corporation. It's simply by putting a sign out on the door, you have a sole proprietorship created. There's really not much to do. I mean, if you wish, you could file for an assumed name if you want, but that's not required. So simply by just opening up your business, you have a sole proprietorship. Taxation. With a sole proprietorship, the income is generally captured on your Schedule C of the 1040. There's only one layer of taxation, no double taxation. Now, there's some disadvantages with a sole proprietorship because there are a number of deductions that a corporation can do that a sole proprietorship cannot. So that's another component that you may need to consider. But the last factor here is unlimited liability. A sole proprietorship does not have limited liability, and that is one of the main reasons why it becomes very unattractive to use a sole proprietorship, especially where you're going to have employees or other parties involved, independent contractors working for you, because as the company gets larger, you have more and more individuals working for you. It becomes more and more difficult for you to really be involved in ensuring that those individuals are not creating liability. And if you're a sole proprietorship, you have unlimited liability. That means your personal assets are exposed to the claims of creditors. So that's one reason why you want to stay away from a sole proprietorship. Next slide, please. Okay, so non-for-profit. So that's a little bit whole different regime of entity selection. With the non-for-profit, there's really two phases with setting up a non-for-profit if you want to be tax exempt. A lot of people don't understand this, but the first step is formation. You file articles of incorporation with the Secretary of State, you obtain the EIN, you register with the various state agencies. But at that point, you're just a non-for-profit corporation. You're not tax exempt at that point. That means at that stage, individuals who make contributions to your non-for-profit corporation, those are not deductible. Please go to the next slide. So the second component with a non-for-profit is tax exemption. So once the company is set up with the Illinois Secretary of State or whatever jurisdiction you're selecting, once that is set up, you go into the second phase, which is applying for and obtaining tax exemption from the Internal Revenue Service. So that entails filing Form 1023 with the IRS. It may take, 6 to 9 months to go through that process. As we all know, the IRS moves pretty slow. Once it's set up, then we would recommend that you register with the Illinois Attorney General as well, because as your donors decide whether they want to make a contribution, many times they're going to look at the Attorney General's office, see if your entity is actually registered. There are a lot of phony charities out there. So registration with the Illinois Attorney General is one way to kind of legitimize your non-for-profit entity. Next slide, please. Flat fee formation. So Lavelle Law, we provide a flat fee formation for any of these entities. We charge a flat fee of $500 for the attorney fees. In addition, there'd be a filing fee that you would have to pay with the Secretary of State. And by the way, that does not include the drafting of shareholder agreements or a multi-member operating agreement. Those gets more complicated and we have to spend more time with that. Next slide, please. Corporate compliance, something that's often overlooked, something I don't want to spend a lot of time on this, but if you have a corporation set up or an LLC, as you probably know, you have to file an annual report with the Secretary of State every year. In addition, corporations should have annual meetings of shareholders, annual meetings of board of directors. We have a great service here, $249 for corporations, $99 for registered agents. It's we make sure the company continues to operate. You don't lose that limited liability shield. We do it for you, so you don't need to think about it. You focus on your business. We worry about keeping the corporation or the LLC in good standing with the Secretary of State. And next slide, please. Real quick, if you're operating out of state, one thing that you have to understand that you may need to apply for authority to transact business in that state. If you're doing business strictly here in Illinois, it's not a big deal. But once you start doing business out of Illinois, especially if you're going to have a business presence, like signing a lease, having a commercial space, we would recommend you apply for authority to transact business in that other state. Furthermore, if you move your business to another state, there are procedures out there where you can domesticate that in another state entirely. Next slide, please. Lastly, real quick, limited liability. We talked about that quite a bit through this presentation here. There are exceptions. First and foremost, guarantees. A lot of times creditors will ask the owners to sign a personal guarantee. Of course, if you do that, you're going to be personally liable. So always be careful when you're signing a contract on behalf of that company. Make sure they're not sneaking in a personal guarantee in there. Next issue in our limited liability, employment taxes. There are exceptions to if you fail to pay employment taxes. There are certain individuals, those responsible individuals can be found personally liable for the failure to remit employment taxes to the IRS. Wages, there are also some statutes. The Department of Labor may come after you if you are a person making decisions and you're choosing to not pay wages to your employees. Lastly, piercing the corporate veil. This is something that could happen. And what that means is if you don't observe the corporate formalities, then a creditor could ask the court to ignore the corporate structure, ignore the limited liability, and basically treat your company, your business, as a sole proprietorship or a partnership, which means unlimited personal liability. So those are some of the limited liability exceptions that you need to be aware of. So that's the end of my presentation here on entity selection. At the end, if you have other questions, later on at the end of the presentation with Steve and Samantha, you can pose other questions. So at this point, let's turn it over to Steve. I don't know, Steve, are you going next or no? Samantha. Okay, Samantha.
Good morning, everyone. My part of the presentation is going to go over raising capital, and in large part, raising capital in the private sense. So through private placement exemptions and the like. You can go to the next slide, please. So what is a private placement or an unregistered offering? Basically, the easiest way to think about this is the definition is it's a securities offering that is exempt from registration with the SEC, but that's not where it stops. So anytime you are, and this is more geared towards raising capital for your business. So a lot of people kind of think that, oh, well, if I'm not an investment advisor, I'm not a private fund, like all of these items are still incredibly applicable and important if you are raising money for your business or raising capital pretty much in any sense. So you need to first think of the federal regulatory scheme, so to speak. Basically, under federal securities laws, a company is not able to offer or sell securities unless the offering has been registered or an exemption from registration is available. So even if you perfectly meet or exceed the expectations, frankly, of a federal exemption, it is incredibly important to still then take it a step down and make sure that you're complying with everything at a state level. Because just because you are complying with all of the federal exemptions does not mean that there aren't state laws and regulations that need to be undertaken. You can go to the next slide. So when you're raising capital, there are considerations that need to be thought of regardless of which exemption you're taking. And interestingly, while we're talking about raising capital in the predominantly private realm, certain of these considerations are actually whether you're raising capital in a public offering. So just know that these are important baseline considerations when you're raising capital regardless. This first one is called a bad actor analysis, and this is for the issuer itself. So the company, its executive officers, beneficial owners, shareholders. So again, dependent on the type of structure that the company is, but nonetheless, you have to basically run this analysis to determine if any of the individuals involved have any disqualifying factors that would not allow the offering to move forward, because that would obviously put a halt to raising capital before you've even started. And this is one of the very preliminary tests that is applicable for almost every exempt offering. And then this next bucket is a lot broader. This is definitely an overview because the facts and circumstances are very subjective. While the laws are objective, there's a lot of different nuances relative to your business that are important to think about. Your primary place of business is a big one. So if you are squarely situated in Illinois and also only raising money from those in Illinois, there are going to be a few exemptions that are applicable to you. That's often the exception to the rule. It's likely that you're going to be raising money from other states. It's likely that you could yourself even have an additional office or branch office. But it's important to think from the onset of where your primary business is operating out of. And then also the types of individuals or companies, the types of investors broadly that you are going to be raising money from, and more specifically, their accreditation status. So that is to say, not just are they a human or a company, but more specifically, are they an accredited investor? Now, it's good to note that the accredited investor definition has broadened up for the first time in decades recently. So a lot of new people are available to be deemed accredited investors and thus eligible to participate in certain offerings that they otherwise wouldn't have been. It's worth noting that it's not to say that you cannot involve unaccredited investors, but when we get into a couple slides later, some of the different types of exemptions that are available to you, you'll quickly be able to realize that by allowing in unaccredited investors, there are definitely certain other compliance obligations that you have to work through. So you've got to think of where your business is located, the types of investors you're going to have, but also how many investors you're going to have, because there are certain caps on those. So if you want to be able to offer to an unlimited amount of people, that's going to basically narrow down these are all actually qualifiers to sort of narrow down what exemption is even going to be applicable for you on a federal and then state level. So it's also important to look at the geographic location, not just of your company, but of those that you're trying to raise money from, as well as if you plan to utilize any general solicitation or advertising, because again, that could exclude out the availability of certain exemptions. You can go to the next slide, please. So these investor documents and regulatory filings, this is just a sample of them. And again, they're applicable for most exempt offerings, but there are ways to work your offering in a way that if you are only going to accredited investors and a limited number, we're certain of these these regulatory filings may not be applicable to your specific offering. But in large part, you can expect that you are going to have a process for investor questionnaires. And that is to tell the accreditation status of your investors to begin with. You could trip up, even if you have perfectly complied with a federal exemption, should you moving forward then offer to an unaccredited investor, all of a sudden you could have tripped up these potential parameters that would have allowed you to work in that exemption. So investor questionnaires from the get-go are incredibly important to make sure you are qualifying each type of investor and also organizing it in a way to make sure that you're organizing by their state, all of the different items that could potentially require some additional state consideration. And a private placement memorandum, this is a legal document that is incredibly important to protect your firm, the offering, from potential liability in the future. It's important that a lot of, it's common misconception that, oh, if I'm just raising money from family and friends, or, oh, well, I'm just doing this type of offering. It's the exception to the rule that you can operate in an offering that doesn't need a PPM. They exist, but even then, I find that issuers still utilize a PPM because it just prevents it also lays out the risks and all of the considerations that an investor needs to make, but it really prevents a lot of the potential liability in the future, as well as is that foundational document that lays out the risks of the offering, all of the various legal and corporate details that need to be in there. And it's really good for all parties involved. The Form D is a federal filing. So it's filed on the Edgar database, and it is specific to each offering. So if you are raising money in different realms and you've got several different offerings, it's going to be specific to each individual offering that you'd have to consider if a Form D is required. And then blue sky filings are state-specific filings. And it's basically just putting a state on notice that you are raising money in that state. And you can avoid certain blue sky filings dependent on the type of federal exemption you're operating under. But again, there's different facts and circumstances for each. So it's important to make sure that you've got them all ironed out from the beginning, that you can, in an organized manner, make sure you're meeting the expectations of both the federal and state level. The anti-fraud provisions are applicable for everyone. Private capital, public capital, if you're raising money from your best friends, your family, everyone in between. This just requires that you provide investors with full, fair, and complete disclosure materials about the issuer, its management, business, operations, and finances. It is most easily done through the four corners of a PPM, along with all of the other considerations that you need to think about. This also goes to how you can market yourself, how you're talking to people about your business, and not just in the putting ads out there on your website or LinkedIn, even just how you're conversing with individuals. It's incredibly important to make sure you're not tripping up any anti-fraud provisions by using like heightened adjectives, promising things that you can't keep, things along those lines. You can go to the next slide. So these are the federal exemptions under Regulation D. I definitely want to point out that there are additional exemptions that exist. Like we kind of spoke of a couple of the kind of concepts about them. So we're not going to get into them today because they're, again, kind of the exception. They're less used, but if you are squarely situated in Illinois and only raising money from individuals in Illinois, there are intrastate offering exemptions, but many of them require you to have been incorporated in Illinois. So these are by and large the most popular and most utilized offering exemptions because they are far less limiting than many of the other exemptions that are available. So we'll just kind of go through them. 504 does have a limit on the amount of capital you can raise. So it has increased to 10 million, but obviously if you want an unlimited offering amount, then you really aren't thinking about 504 because it has a cap. So you cannot raise more than $10 million. And this is in a 12-month period is how the offering limits are kind of scoped. The Form D is required. And again, all of these, you kind of have to think of that next step. Like, where are your investors coming from? Do you have 50 investors in a certain state? Because then you might need to think of those individual state regulatory exemptions separate from meeting 504. So again, 504 is the one with the cap. That's kind of the biggest limiter there, but it is definitely a very popular and utilized exemption. 506B and C are more popular. So 506B is arguably the most popular of the offering exemptions. Now, it does have a limit, but not in the amount of capital you can raise. For both 506B and C, it's an unlimited offering amount in a 12-month period. The Form D filing is still required, but fear not, those are very navigable filings that we can absolutely do for you at Lavelle Law, so don't worry about that. But 506B, while you're allowed to sell to an unlimited amount of unaccredited investors, it does put a cap on your accredited investors, so you can offer your offering to no more than 35 unaccredited investors. So that is where the investor questionnaires come into place. And this is strict. I mean, this means that you can't have like a 36th family member that's coming in unless they're meeting an accredited investor definition. So you might think like, well, they're just family, because I hear that so frequently that, you kind of think of common exceptions, but they don't exist. These limits are strict. So every individual needs to be qualified into one of these items. And in this offering, the reason why this winds up being the most popular offering is often people choose to still exclude unaccredited investors, because if you do allow unaccredited investors to come in, it does then require you to have additional disclosure documents for those unaccredited investors. And then it's a best practice and a common business practice to provide whatever disclosures you're providing to the unaccredited investors across the board to all of your investors, which frankly, accredited investors are going to expect those docs. They're familiar with seeing them, PPMs, subscription docs, but it then becomes an absolute requirement. So that's something to think about when you're kind of structuring your offering and who you plan to raise to, how much money you plan to raise. So Rule 506C is popular because it was the newest that allowed general solicitation and advertising. Now, that is to say, it does exclude unaccredited investors. So you have to utilize this offering for only accredited investors. And additionally, there are enhanced suitability requirements. So in any of these senses, there's different limits or caps on the type, but these are three really good federal exemptions that generally are operated under. Go to the next slide, please. So while I said that we are going to focus on raising private capital, I wanted to at least touch on ways that are markedly different in that they're in the public sense, but they are more navigable than you might think of a traditional public offering. So that is regulation crowdfunding, which enables eligible companies to offer and sell securities, but this is done through an SEC registered intermediary. So there are other service providers involved, so to speak. So this is done online and it has different disclosure requirements. It's called the Form C, so it's filed with the SEC. And you do then have various ongoing disclosure documents that are posted in a far more public sense than all of the other exemptions and ways to raise capital that we've talked about. Okay, we can go to the next slide. So in regulation crowdfunding, you can raise up to $5 million in a 12-month period. So that is an increase from the previously stated thresholds. But that being said, if you do choose to use that upper threshold of raising up to $5 million, it does require audited financial statements. So again, with each of these considerations, it's increasing costs, and especially in the public capital raising sense. That's why the focus of this presentation is private capital. And so investment limits, accredited investors have no investment limits for crowdfunding, but non-accredited investors do, and they can use the greater of their annual income or their net worth when calculating how much they can contribute to a reg crowdfunding offering. Okay, next slide, please. So Regulation A offers two exemptions, and they're two different tiers. So in both tiers, a Form 1A is going to be the required disclosure document that gets filed with the SEC and provided to investors. And then the basic requirements for both tiers are the same in that it goes down to company eligibility, the bad actor qualification and provision that we talked about, and various other disclosure matters. Next slide, please. So the tier offerings depend on on how much money you want to raise, excuse me. So in tier 1, you can raise up to 20 million, and in tier 2, you can raise up to 75 million. Again, all of these are on a 12-month offering period. And just note that there are, of course, additional requirements for tier 2, which makes sense. It tracks with everything else because you're raising more money. So there are certain limiters in that regard. Okay, I think that that's the end of the private capital. Steve?
All right, Steve, you want to take us over shareholder and operating agreements?
Yeah, before I start, Kaylee and Lisa, can you tell me how much time I have?
Yeah, you have about 10 minutes.
Okay, good. So I might have to rush through some of these, but that's all right. All right, next slide. All right, so what we're going to do is we're going to talk about shareholder and operating agreements. So like Ted mentioned, when you have multiple members or multiple shareholders, you'll definitely want to get a shareholder and operating agreement in place. And these are going to be more complex than if you were, say, a single member LLC, in which case it's just a couple of pages, pretty easy to knock out. But if you have multiple owners, then you'll want to definitely get one of these agreements. And broadly, when we kind of review these or draft these, we kind of look at these kind of 5 major categories that are listed here. So we'll take each of them in turn. Next slide. All right, management continuity. So oftentimes we see with these agreements that the shareholders or the members want to control who's on the board of directors or who the managers are. Oftentimes they want to lock in and prevent any sort of changes in the number of directors and managers. We want to appoint the various officers. Sometimes we see the use of proxies to control voting. But the overall goal really with management continuity is to just ensure a smooth operation of the business. We know who the directors are going to be. We know who the managers are going to be for an LLC, and so we kind of know who's going to be kind of controlling and running the business day to day. So that's the first category I want to talk about. Next slide. All right, so around our office, we talk about planning for the 3 Ds when it comes to these kind of major events that we consider when we draft these shareholder and operating agreements. So you really want to have a plan in place that's spelled out in your shareholder or operating agreement for either death, disability, or divorce. So again, those are the 3 Ds. Sometimes it's other triggering events too, and I list them here. But really, a lot of times it's, if there's a death of a shareholder or member, disability, or divorce, you want to know what's going to happen to that equity interest that person holds. And you want to kind of provide for that in these agreements. Next slide. Kind of related to that is the whole transferability issue. This is a really big issue in these agreements. So again, for each of those 3 Ds, you want to consider what's going to happen with that membership interest. And typically what we often see is kind of a blanket prohibition on transferability, except for certain, permitted exceptions. And there's often two basic approaches here. So one, the company itself can redeem the equity interest of the dead or disabled shareholder or member. And sometimes too, it could be a cross purchase where, the owners have the right to redeem that interest. But it's really, really important to understand, who holds the option and who's got the ability to exercise it. I'm going to pose a hypothetical to you guys, and feel free to jump in the chat. But let's just take the example of a minority shareholder or member. Maybe they own 10 or 20% of the company. So what happens then upon the death of that owner, right? So there's a 20% interest then that the deceased owner or the estate of the deceased owner holds, right? So if you're the successor trustee of that owner's trust that holds that interest, for example, or maybe even the surviving spouse, what's your primary concern with respect to that equity interest? What do you want to see happen to it? Go ahead and type it in the chat. Anybody have any idea? If you're the surviving spouse or executor, trustee, what do you want done with that equity interest? Anybody have any idea? Financial advisors especially should know this answer. Okay, it's one word, begins with L. Very good, Brian got it. Liquidate and distribute to the heirs. Yeah, they want liquidity, right? They don't necessarily want to be involved in managing or operating the business. They want to cash out, take that money, reinvest it, and distribute out according to the trust or the estate or what have you. And then they usually want to kind of not be involved in the business anymore. But so that's one consideration from the deceased owner's perspective. But if you're the other managers or the other members or shareholders, right, and you have the death of a 10 or 20% owner, then you're thinking, well, I don't necessarily want to have to redeem them. They can stay on. I'll give them their profit distributions, and they don't have enough of a vote to really matter much. So let them stay around. I don't really want to have to redeem them. So there's that tension there, right, between the surviving owners and then the deceased owner that you really have to resolve, and you really kind of have to figure out what's going to happen upon death or disability, certainly of that owner. And so oftentimes we see, to be fair, I guess, for everybody, because again, this can probably happen. Any of these owners can be in that situation, right? So what we often see is some sort of redemption or cross purchase ability to be able to offer that liquidity for the deceased or the disabled owner. All right, next slide. Okay, so related to transferability, how are we going to value that equity interest, right? So again, we really should be fair to everybody here, because again, any of these owners can be in this situation. So we want to, the goal is to try to accomplish a fair value that applies, to all the owners. And so really there's three approaches that you can use: some sort of appraisal requirements, a formula for valuing that interest, or an annual agreement among the owners that they kind of meet and decide annually. Most often we see kind of an appraisal or formula in terms of the most popular choice for valuation. As part of the agreement too, we want to allow for these permitted transfers. I mentioned earlier estates and revocable trusts as owners of these equity interests, and we often see and allow for an owner's revocable trust to own that interest. So you want to allow for that type of transfer. And if the company has redemption obligation, then you often too want to fund that obligation with life or disability insurance, so that the company has the cash to be able to make that purchase. So oftentimes we work with our financial advisors and insurance agents, to put that insurance in place. Oftentimes too, if the purchase price is going to be significant, we'll want to make those payments in installments. So we'll set up an installment sale, which could be good for tax purposes. And then also we want to specify, the interest rates and all that. And sometimes too, we'll want the ability to expel a shareholder or member if they're just, not performing as expected. Next slide. All right, so if we do allow for disability as one of the events that could trigger redemption or cross purchase, we want to make sure that that disability definition, ties into disability insurance if the company is going to take out disability insurance, or if the other owners are going to take out disability insurance on each other. We want to kind of make sure that those disability definitions that are in the agreement, match with what's provided in the policy. And then also with respect to the shareholder and operating agreement, we want to make sure that it complies with the estate tax provisions in the code. And these are kind of the 3 requirements I list here that have to be satisfied in order for the IRS to respect that shareholder or operating agreement for purposes of estate taxes. So next slide. Another objective we try to achieve with respect to shareholder and operating agreements is really it's a form of a non-compete, right? So we often see non-competition and other restrictive covenants in employment agreements, but really here in a shareholder and operating agreement, it makes a lot of sense, and it's certainly more enforceable because it's not specifically tied to employment. It's tied to owning and operating the business. So the courts are more comfortable, certainly, enforcing them. The consideration is more clear because we have people, putting in capital and performing services for the business. So, overall, it's going to be a lot easier to enforce and case laws really kind of bore that out. So, if you really want to prevent your fellow members, investors from competing with you, that's a really good place to do it, is to put it in that shareholder and operating agreement. Next slide. All right, and then finally, the last objective we often want to accomplish with the shareholder and operating agreement is to ensure that down the road there's an exit, right? We want to make sure that the company can get sold. So there's a couple different ways to accomplish this: drag along and tag along rights. So first, the drag along rights, it really kind of protects the majority shareholder, because then you're with the drag along right, the majority shareholder is able to drag the minority shareholders with them to ensure the entire all the equity interests get sold. So that, for a prospective buyer, that can be very important to make sure that they can purchase all the equity interests. And kind of the flip side of that, with respect to protecting the minority owners, oftentimes the minority owners want to participate in a sale. Maybe the majority shareholder, remember, got some really good terms from a prospective buyer, and they want to make sure that they can kind of participate in that transaction. So, maybe we'll want to consider putting in tag-along rights to protect the minority owners, to ensure that they can participate with respect to any sale of the majority of the equity interests. And then sometimes too, with respect to, last bullet. So sometimes too, we'll want to define voting requirements to approve these sales. Oftentimes, the Business Corporation Act, the default rule there is 2/3. Maybe we'll want to tinker with it. Maybe we'll want to make it 3/4 or something that's not a default rule. So a good place to do that is you can put in a shareholder operating agreement to provide for that sort of modified approval requirement for a sale or a merger. Next slide. All right, so I kind of ran through that kind of quick. I think we'll open it up now for all.
Thanks, Steve. Yeah, thanks a lot. I don't know if you have time for questions or not. Certainly you guys can contact us. By all means, we'd be happy to answer any questions you may have. Shoot us an email, give us a call. Happy to do that. I want to turn this back over to Lisa and Carrie Ann at this time.
Thank you, Ted, and thanks, Samantha and Steve. There's the contact information on the slide right now. So much great information. I got 2 texts. This entire presentation will be on our blog by the day's end. So if you have questions, if you want to go through this again, feel free, go to our blog, take a peek. Otherwise, feel free to reach out to Ted, Samantha, and Stephen with the contact information on. And then I wanted to thank the presenting sponsors, and supporting sponsors, excuse me, with some raffles. Harper College, Amy, would you like to take it away?
Sure. Actually, Lisa, I'll have you help me out. Can you select a number between 1 and 8 for me? 5. Okay. Always got to keep it fair. 555. Hey, Mr. Tom, you get yourself a Harper swag bag. I'll reach out to you and get your address. Thanks, you guys. We are happy to be here and be a sponsor.
Thank you so much, Amy. And then links, I think Brittany, you had a Amazon gift card you wanted to raffle off.
Yes, we're giving away a $100 Amazon gift card, and it's going to one of our speakers, Samantha. So thanks so much for the presentation today. We're happy to be here.
Thank you, Brittany, and thanks, Links. Melanie with Vicarious Multimedia.
Hi there. Good morning, everybody. So the lucky 13 winner is Katie Bergansky Frank. You get the $100 gift certificate to Golden Brunch, because what we're trying to do is make sure that we're supporting our local restaurants. Fortunately, the world is opening up. That's great news, but I think they've been hardest hit out of most businesses. So, Katie, Golden Brunch.
Congratulations, Katie. And Matt Frank, do you have an update you'd like to share on behalf of the village?
Yeah, thank you for the opportunity. Speaking of restaurants, the village rolled out its 3rd small business program. This one is geared to our restaurateurs. So they're eligible for up to $20,000 from the village of Schaumburg, depending on the low mod payroll hours. So if you know of local restaurants, please have them reach out to me, and we hope to take their applications here shortly and get that money back into the community. Thank you, Lisa.
Absolutely. Thank you, Matt. And thank you again, Lavelle Law. This was such great information, incredibly timely. We could not do all of these events, provide all these resources without the membership. So thank you. Kind of to echo everybody's sentiments, support local, support Schaumburg Business Association, support local. Here's some in-person events we have coming up, those limited pop-ups, all in person. And then coming up for the rest of the month, new member orientation, leadership luncheon, and coffee and contacts will all be mixed virtual. That means we will be in person, but there will always be a virtual option. So we hope to see you soon. Enjoy your day. Thank you.